Copy of the court's instructions. Does the state have a copy of the court's instructions?
The state does, Your Honor.
Defense?
We do, Your Honor.
All right. Does the defense have a copy of the state's instructions?
Yes, Your Honor.
Does the state have a copy of the defense instructions?
Yes, sir.
All right. C1, C2, C3, C4 will be given. Objections for the record by the state.
No objection, Your Honor.
By the defense.
No objection, Your Honor.
I'm going to withdraw C5. Just for the attorney's knowledge, this was an old set of pattern instructions. That one hasn't been given in this district. Long time. Long time. All right, C6 will be given. Objections for the record by the state.
No objection.
Objections for the record by the defense.
I'm sorry, Your Honor.
C6, defendant's right not to testify.
Yeah.
No objection.
All right. All right. Let's move to S1. Any objection by the defense?
No objection, Your Honor.
S1 given without objection. S2, any objection by the defense?
No objection, Your Honor.
S2 will be given. S3, any objection by the defense?
No objection, Your Honor.
S3 will be given. S4, any objection by the defense?
No objection, Your Honor.
S5, any objection by the defense?
No objection, Your Honor.
S5 will be given. S6.
No objection, Your Honor.
S6 will be given. S7.
Your Honor, I don't think this one, I don't think this was an issue in this case. It wasn't about being sentenced.
Response.
Sir, I believe that there was quite a lengthy bit of testimony regarding the fact that the defendant had used drugs at or near the time of the crime. And we do believe that it certainly goes to assisting the jury in understanding that if they believe that she was impaired by her own doings, intoxicated by smoking weed, that is not a defense to a specific intent crime such as murder or attempted murder.
All right, can you reply?
Yes, Your Honor. The testimony in this case was very, how do I say it? It was very straightforward. She wasn't intoxicated at the time that it happened. This is not an issue in this case by any witness.
The objection will be overruled. It will be given over objection. All right. Now, D1 is a peremptory instruction. The court's going to refuse that without argument, so to preserve the appeal.
Yes.
All right.
Yes. Yes.
We've already heard the motion for directed verdict. I'm marking that refused. All right. D2 will be given. Objections by the state for the record.
Or none other than they've already been instructed of that.
Be given over objection. All right. D3, objections by the state.
I think it's probably covered in the court's instructions.
Be given over the state's objection. All right. D4,
State objects. They're attempting to find reasonable doubt.
response.
And Your Honor, I think we've had this given multiple times in just about every case. This is not an attempt to define reasonable doubt.
Any reply?
All right. Very clearly is attempting to define reasonable doubt when it says there's always a reasonable doubt, and then it goes on to give examples and then talks further about that.
D4 will be refused based on Simmons versus State, August 6, 2024 Court of Appeals case. Deals with this exact instruction, citing Fulgen versus State, 46 Southern 3rd, 315, as an attempt to define reasonable doubt. All right, D5, objections by the state.
Same argument, Your Honor. I think that the first part of that is a correct statement of the law and was already included in our instruction, and the rest of that is an attempt to define reasonable doubt.
Response.
This is a McNaughton, or is this a McNaughton one for us?
This is your McNaughton instruction.
Yeah, this is from the, that's what I thought. This comes from the, I guess the, what do we call it, the Mississippi rules.
The pattern instructions. Yeah, unfortunately, a lot of the pattern instructions have been
Modified?
have been denied. So, court's going to rely on Jackson versus State. It's 2024 unpublished opinion. Westlaw 228-2840, particular paragraph 60 to 61, and Hearn versus State, cited 3 Southern 3rd 722, page 739, paragraph 51. In particular, what the court's looking at is there is already a complete statement of the law as to McNaughton in the jury instructions. For that reason, in the case is cited, we have there is a complete McNaughton instruction that makes it very clear it is the state's burden to prove that beyond a reasonable doubt. All right. That'll be the basis of the court's ruling. D6, objection by the state.
State objects again, attempt to define reasonable doubt.
Your Honor, I think we've had this one given. I don't know if there's another 24 case that overturns it.
No. So this particular instruction, the court's going to deny this instruction. This particular instruction is routinely given in federal court. However, in state court, Vaden, Jones, Barnes, Boutwell, Simmons versus State, as recently as a few weeks ago, have upheld that this is an attempt to define reasonable doubt under our state law. I'm aware that they're, for appellate review, understand that this is given by federal courts. However, this court would urge the state of Mississippi to maintain its almost century-old practice of not defining reasonable doubt. And I'm going to be frank, I'm not being ugly to anybody on the appellate courts. I have put as many juries in the box as anybody else. Juries don't need a definition of reasonable doubt. They know what it is. For that reason, and the cases that are cited, that will be refused under that long line of cases. All right. I'm not putting the cart before the horse. However, I want to at least look at the sentencing instructions tonight if they become necessary. The only reason I want to do that tonight, this will be the first case tried since the legislature took a whack at the Miller problem. So, we're on new ground here. Now, that being said, is there an objection to state sentencing 1?
And Your Honor, I saw the states, ours is different, and I think it's this Miller issue.
Miller and Thompson, right.
Yeah, so my question is, we did one that is a little different because we weren't sure which one is correct.
So let's take it one by one. I'm not sure anybody knows what's correct yet, Mr. Camp. We're in brave new water, okay? So that is no fault of yours. The Supreme Court of the United States handed down Miller versus Alabama. All Miller versus Alabama says is that a juvenile cannot be automatically sentenced to life without the possibility of parole. Automatically sentenced. The Mississippi Supreme Court then said it is a jury question post-Miller. I agree that is absolutely the law. What complicates this case, this is a murder case, not a capital murder case. However, in the state of Mississippi, life imprisonment under current law means life imprisonment. There is no parole. Now, Give the legislature a moment, that'll change. Okay, I mean, just give them a year, and that'll change. But nonetheless, that's where we are. So I believe we have to have the Miller factors heard by the jury. So is there any objection to these Miller factors in state sentencing 1?
No, Your Honor.
All right. Is there any objection to the sentencing schematic that the state lays out? So in other words, just to count 1, if they can affix 3 possible sentences. They can say, we sentence her to life imprisonment. They can say, we sentence her to life imprisonment with the possibility of parole. Now, all the cases in the past have been notwithstanding Section 99-19-101. However, this is technically Section 47-7-3. I can't remember code sections very well. But basically, the way the law in the state of Mississippi works is we have this huge section that gives all the reasons to parole folks. One thing in there says, shall not be eligible for parole. Capital murder, murder. Those are the 2 that are not eligible for parole. So, any objection to this instruction if we get there, Mr. King?
And Your Honor, I think we're talking about...
SS1 and SS2 are identical.
Yeah, no objection.
All right. Now let's go to DS1 and DS2. Do you wish to withdraw those?
We would withdraw those, Your Honor. We did them because we weren't... It's the opposite of if we didn't need the language, we had one.
You technically followed the statute verbatim, Mr. Camp. Okay, you are correct in following the statute. However, I think the state is correct, and there's no need for us to hide the ball from the jury. Even though I'm saying this on the record, and I'm sure they'll take a whack at me, and I deserve it. We'll get the question: how long before she's eligible for parole? And the short answer to that is as quick as possible. I can't tell the jury that, though.
Right.
I can't tell the jury what the parole board will do. And the appellate courts have chastised me already for any comment I've made on the parole board, so we'll shut my mouth there. But the bottom line is, nobody can tell us when she would be eligible for parole. The best guess right now, I think, is 10 years. I mean, that's kind of the dartboard guess, right? I don't know. I mean, that's the closest I've come to. So, DS1 and DS2 marked withdrawn, correct?
That's correct.
All right. Let me put these instructions over. While I'm doing that, I'm going to begin all that were withdrawn or refused. I'm going to hand to Ms. Eaton, have you mark those as courts next for ID. You need your reaction to think about this with the
20 minutes, please.
okay, what kind of warning would you like? Well, before we do that, is 40 minutes sufficient for the state? Please say yes. We don't need a feature film.
Yes, sir.
I understand that y'all have heard my speech about this too many times. Can the state do it in 40 minutes?
Yes, sir.
All right, that's a total of 80 minutes of argument. All right, Vince, how do you want to split your time evenly? Evenly?
We are.
All right, y'all get a 2-minute warning. Okay. If you want 2-minute warning instead.
We can do it 2 minutes.
All right, everybody gets a 2-minute warning. All right. Give me just a moment. Let me get these instructions in order. Court will read out the instructions as follows. S1 will be jury instruction number 1. Excuse me, C1 will be in jury instruction number 1. C2 will be jury instruction number 2. C3 will be jury instruction number 3. C6 will be jury instruction number 4. S4 will be jury instruction number 5. D2 will be jury instruction number 6. D3 will be jury instruction number 7. S1 will be jury instruction number 8. S5 will be jury instruction number 9. S3 will be jury instruction number 10. S6 will be jury instruction number 11. S2 will be jury instruction number 13. And C4 will be jury instruction number 14. Always, the instructions will be on the bench before me. If either side needs to use them, they are free to use them. However, if you take the instructions, you should return them back up here in the same order that I put them in. Any questions tomorrow by the state?
No, sir.
By the defense?
No.
All right,
Did you say we could get a copy of them? I know you said they were going to be out there.
shoot a copy. Okay. Does the state like a copy too?
Yes, sir.
All right. Shoot 2 copies.
I don't have to organize that.
Rex, I think we're going to do pens for lunch tomorrow. Okay. If you would, let's get that finished. I think Miss Michelle's going to put together the order tomorrow. So if you would, please give her in the morning. Make sure she does that. Miss Blondie, you know I'll stay. Go back. All right, y'all can step up to Miss Burrows over here for the very last time. Burrows. That's right. Miss Burrows is getting married on the courthouse steps tomorrow. Yeah, yeah. I'm not sure that's how she draped the things. No, she got the nice jets. What are you thinking? Nice. All right. Anything further from the state?
Before we leave tonight, can we get Mr. Levison to set up the TV for closing tomorrow, or would you just prefer him to do that tomorrow?
You can do it anytime you want. You're on Rex's time, though, so when Rex kicks you out, you got to go. All right?
Yes, sir. I understand.
Anything further?
No, sir.
Anything from defense?
No, sir.
All right. Best of luck to both sides tomorrow. Mr. Shipley will give you your time. Be ready to start as soon as we roll in, okay?